Impeachment ni Sara, finally unconstitutional na. What do you get when you sit on multiple complaints and wait literally 2 months before acting kasi inaantay mong magpasabog at magkuha ng mga pirma bago mag-adjourn ang Kongreso?
Wala pa eh. Wala pa silang sinasabi sa akin. I think the situation now, if I can describe it, is wait and see. It's wait and see. Especially with the rally of the Iglesia ni Cristo. No? I think that will be taken into account by the House members concerned.
Wait and see what, sir? What do you mean wait and see what?
Wait and see whether they will really file another complaint or not. Then I'll be forced to transmit these 3 complaints to the office of the Speaker.
Eventually spelling out the demise ng isang impeachment complaint that was endorsed by literally hundreds o more than 2/3 na mga kongresista. A once-in-a-lifetime opportunity squandered kasi nga ikaw, masyado kang mabagal.
Secretary General, please respond.
Mr. Speaker, as of the present, the total number of members of the House of Representatives is 306.
The majority leader is recognized.
Mr. Speaker, may we inquire from the Secretary General how many members of the House verified and swore before him the impeachment complaint?
Secretary General, please respond to the query of the majority leader.
Yes, Mr. Speaker. Pursuant to Section 14, Rule 4 of the Rules of Procedure, in impeachment proceedings, the total number of House members who verified and swore before me this impeachment complaint is 215 House members.
Issued with finality, ibig sabihin walang tsansang umapela pa uli. Declared as unconstitutional na ang ginawa ng House of Representatives sa pang-4 na impeachment complaint laban kay Vice President Sara Duterte. Pinagpapatibay ng unanimous decision na ito ang isa pang unanimous decision nila last year sa pagdedeklarang unconstitutional ang pang-4 na impeachment complaint laban kay VP Sara Duterte.
Good afternoon. By a unanimous vote of all those participating, the Supreme Court en banc denied with finality the motion for reconsideration filed by the House of Representatives, which sought to reverse the Court's July 25, 2025 decision that declared the articles of impeachment against Vice President Sara Z. Duterte unconstitutional. It affirmed that the 4th impeachment complaint transmitted to the Senate on February 5, 2025 was already barred by Article 11, Section 3, Subsection 5 of the Constitution.
This is despite dating House Speaker Martin Romualdez's pleading sa kanyang motion for reconsideration na i-reverse ng Supreme Court ang kanilang ruling. A tall order kasi nga, again, unanimous ang desisyon ng Supreme Court among the voting members.
With full respect to the Constitution, in defense of institutional balance, and in the name of the Filipino people, the House of Representatives has filed a motion for reconsideration before the Supreme Court. This is not an act of defiance. It is an act of duty. We do not challenge the authority of the court. We seek only to preserve the rightful role of the House, the voice of the people, in the process of accountability. Let us be clear. The Constitution says the House of Representatives shall have the exclusive power to initiate all cases of impeachment. That power is not shared, not subject to pre-approval, and not conditional. Yet, in GR number 278353, the Supreme Court ruled otherwise, based on a misreading of facts and a retroactive imposition of the new rules. On February 5, 2025, the House transmitted the fourth impeachment complaint, filed and signed by 215 members, to the Senate. Only after this transmittal did we archive the earlier three complaints. The sequence matters. It proves there was only one valid initiation, not four. Even the court's own precedent, Francisco versus House, supports this. Only one impeachment can be initiated, and that initiation begins with a one-third endorsement or a referral. That is exactly what the House did. The court also said the Vice President was denied due process because she was not furnished a copy or given a chance to respond. But nowhere in the Constitution is that required before transmittal. In fact, in all past impeachments, the trial and the right to be heard take place in the Senate. To invent new rules now and apply them retroactively is not just unfair, it is constitutionally suspect. Let me say this with candor. A government of laws cannot allow any branch to become the judge of its own accountability. The Supreme Court is a co-equal branch of government. Its wisdom is deep, its authority is real. But its members, like the President and the Vice President, are also impeachable officers. When the court lays down rules for how it or others like it may be impeached, it puts itself in the dangerous position of writing conditions that may shield itself from future accountability. That is not how checks and balances work. We filed this motion for reconsideration not to provoke, but to protect. Not to assert supremacy, but to restore balances. Because if impeachments can be blocked by misunderstood facts or rules made after the fact, then accountability is not upheld, it is denied. To dissent is not to defy. To demand accountability is not to destabilize. To insist on constitutional integrity is not to weaken democracy, it is to strengthen it. We speak now not because it is easy, but because it is necessary.
Pero may binago sila sa kanilang ruling. Binago nila yung isa sa mga dahilan kung bakit nila binasura ang impeachment complaint, deeming it as unconstitutional last year. Ang problema kasi, nung nag-file ng mga unang impeachment complaints laban kay Duterte noong December 2,
Ito pong complaint for impeachment ay pinirmahan ng 17 complainants na mga galing sa civil society organizations, galing din sa religious sector, galing din sa ibang grupo. But they are filing all of these signatories, 17 signatories, are filing this in their personal capacity, even if they are members of various groups or of various party lists, etc. So, 17 po sila.
December 4 at December 19, 2024, inabot ng almost 2 months bago aksyonan ng Kamara when it was basically archived noong mag-adjourn sine die ang Kongreso last year at ma-transfer o ma-refer na to the Senate yung impeachment complaint with the signature of more than 1/3 ng House of Representatives. Noong July, inacknowledge na within 10 session days naman ang ginawa ng House leadership. Meaning, hindi mapapaso at iba ang dahilan kung bakit unconstitutional ang impeachment. Hindi dahil mabagal sila kumilos, na nag-aantay pa sila ng pang-apat na impeachment complaint na para sa lahat ng pangmalakihan, pangmaramihan ang boboto para ma-fast track yung impeachment complaint. inacknowledge nila na walang mali doon, that it is done within 10 session days. Meaning hindi mapapaso at iba ang dahilan kung bakit unconstitutional ang impeachment. Dati kasi, ang isang session days ay pwedeng tumagal ng ilang araw, maybe even weeks. Pero ngayon, nagbago dahil ayon sa desisyon, kapag sinabing 10 session days in the context of an impeachment proceedings, ang sinasabi doon 10 calendar days daw yon kung saan may session ang Kongreso. Ibig sabihin, dahil Monday to Wednesday ang pasok ng House of Representatives, 3 session days na sa isang linggo in the context of an impeachment proceedings ang makakount. Ibig sabihin, they were approximately late around 20 session days na dapat hanggang 10 session days lang.
First, the first 3 impeachment complaints filed in accordance with the first mode of initiating an impeachment, that is, Article 11, Section 3, Subsection 2, were not placed in the order of business within the required 10 session days. It further elaborated that an impeachment complaint filed in accordance with the first mode of impeachment, which is Article 11, Section 3, Subsection 2, is deemed initiated for purposes of the 1-year bar in Article 11, Section 3, Subsection 5 when A. A properly verified and endorsed impeachment complaint is referred to the Committee on Justice. B. A properly verified and endorsed impeachment complaint is not placed in the order of business of the House within 10 session days, or referred to the Committee on Justice after it has been put in the order of business within 3 session days, as required by Article 11, Section 3, Subsection 2 of the Constitution.
We shouldn't dwell on it, pero marami ring nagsasabi na napaka-stricto nito. Lalo na at may sinabi pa na kailangan bigyan ng pagkakataon ng isang nang-impeach at ini-impeach para magbigay sa lahat ng miyembro ng House of Representatives ng kopya ng ebidensya nila laban sa isa't isa, either for defense or for the agro. Di ba nga mabibigyan na ng pagkakataon ng isang ini-impeach na official na depensahan ng kanilang sarili kapag trial na nila sa Senado. Hindi na kailangan sa House of Representatives kung fast track. Kumbaga ang way mo is the fast mode para i-impeach ang isang official. Na marami ang nadismaya sa naging desisyon ng Kamara, particularly Senate President Tito Soto, saying na it's a judicial amendment sa Constitution, na it's a judicial overreach. Basically, pinahihirapan ang impeachment process dahil sa mga bagong rules raw.
In upholding its original decision, the Supreme Court also affirmed that its ruling does not absolve VP Sara Duterte of the offenses she is accused of committing. The court's decision was based on procedural grounds and did not rule on the merits of the allegations against VP Sara. Kaya nga, pwedeng magsampa uli ng impeachment case laban kay VP Sara, even with the same substantive grounds contained in last year's complaint. However, while it basically rests on technicalities, the resolution denying the motion for reconsideration appears to be a derogation of the House's constitutional powers and prerogatives. Ang nagkapareho dun sa main decision or original decision at sa resolution ngayon at nakakabahala pa rin, tulad sa naunang desisyon, may paglihis ang Korte Suprema sa letra at diwang nasa saligang batas ukol sa pantay at magkahiwalay na kapangyarihan ng hudikatura at lehislatura. As the latest SC ruling closes several doctrinal loopholes in its original decision, the court also took the opportunity presented by the motion for reconsideration to restructure, refurbish, and refine novel doctrinal pronouncements via an addendum to the original ponentia. As such, this second decision appears to me as not merely a denial of the MR or an affirmation of the original decision. It reads like an altogether new decision, but with the same result. By redefining what constitutes the initiation of impeachment and by converting legislative inaction into a constitutionally operative act, the court has crossed from interpretation into legislation. It is judicial legislation, well-intentioned perhaps, but constitutionally infirm, because it straitjackets a co-equal branch through judicial overreach. The Supreme Court has not merely reviewed the House's compliance with clear constitutional commands, it has rewritten the operating manual for impeachment initiation. It has supplied new rules, new timelines, and new consequences that are nowhere found in the text. The effect is to discipline the procedure that the Constitution left for Congress to decide. This sets a very dangerous precedent that weakens separation of powers by transforming impeachment from a political safeguard into a judicially managed process, contrary to the design and spirit of the Constitution.
Pero don't worry, dahil ilang araw na lang, malilift na ang 1-year bar at pwede na ulit i-impeach si VP Sara Duterte, headed by none other than probably the Makabayan Bloc. Pero siguro hindi na yung katulad last year na I think more than 2/3 ng House of Representatives bumoto para i-impeach si Sara Duterte. Hindi na mangyayari yung ganon. That's truly sui generis, unprecedented at one of its kind. Kaya naman ngayon, and this is kind of disappointing kay Soto, he is proposing probably a cha-cha para ma-amendahan ang konstitusyon para lang mapadali ang pag-i-impeach ng isang official para makorek kuno ang desisyon ng Supreme Court.
What we can do is meet with them. I mean, Congress, House of Representatives.
Okay.
Pag-usapan lang yung issue niyang, pag-usapan namin yan. Kasi, ang nakikita ko na outright solution dito, which could not be called outright, palitan na natin konstitusyon. Baguhin na natin. Pagka ganyan, ano? Pagkatapos, marahil yung Constituent Assembly makakagalaw dyan para or maghihintay tayo decades. It will take years, mga retirement bago tayo sana makakilos at mailagay natin uli sa lugar sa konstitusyon natin. Kung hindi nila ako ayoko ng CONCON, ayoko ng Constituent Assembly, pero pagka ganyan ang usapan, payag na ako. Dati nga madali, sapagkat yan talaga nilagay sa konstitusyon niya ng mga gumawa ng konstitusyon, lalo na yung option 3 na sinatawag nilang option 2 na 1/3 signatures lang, forward na kagad. Hindi ba dati nga prayer lang, finorward na di ba? Sapagkat mayroon ng 1/3 na nakapirme. Hindi pwede magtagal. Kaya nilagay yun dun bakit natin pahihirapin ngayon? Katulad ng ginawa ngayon at humihirap na. Talagang kaya sabi ko, forgive me, but I think impeachment now is an impossible dream.
Ang video clip na ito ay galing sa aking series ng News sa Verdi Rica. Check the entire videos for the complete weekly news recap and subscribe to the channel to be kept up to date sa mga local at global news na I'll make sure will be interesting to you. Particularly you, whatever your name is. Hindi ko alam, sorry. Salamat sa panonood mga kaparami. Like, subscribe, follow me like sa socials and avoid Joseph that will be linked down below. So, of course, paalam.